All right, so now that we've done what I think of as the setup for talking about civil liberties, let's move on and talk about specific amendments, talk about roughly where we are on each of those amendments over time. Also, really quickly, make sure, please, that you check out that wonderful video called Constitution USA, hosted by Peter Sagal. The one I think that I've posted on civil liberties is called, oh bloody heck, what is it called? It's a Free Country. Check it out. It's pretty wonderful. And if you watch that and listen to this and read over the lecture notes and read the book, the chapter on civil liberties, you'll be good to go indeed. All right, so let's get started. All right, let's transition into talking about particular amendments in the Bill of Rights. Let's start with the First Amendment. Congress shall make no law respecting an establishment of religion. Those are the very first words of the very First Amendment to the Bill of Rights. All right? So this was first and foremost right on the founders' minds. Because, right, they had come from a country, England, that had an official state religion, the Anglican Church. Right, created by King Henry VIII, I believe, hundreds of years before, because the Catholic Church was interfering with his efforts to get a divorce. And so he said, the heck with Catholicism, get out of here, Pope. And he created the Anglican Church, basically the Church of King Henry VIII, to give him his divorce, and he would be the head of both state and church. Right? So clearly the founders didn't want that. But they also said no law respecting an establishment of religion, right? Anything that gets too close to that outcome of an official state church. So it's, well, you know, there's kind of a spectrum and there's gray areas. Two ways to think about the Establishment Clause. Accommodation, that the government should accommodate all different religious traditions equally. Don't favor one over the other, no thumb on the scale. And that's a way to do it. And I would say in recent years in particular, I'd say the last 20 years, the court has become increasingly accommodationist, permitting some integration of church and state within limits. Yeah. And often on behalf of mainstream religious groups. All right. And look, some applaud that as correct, and others boo it as incorrect. Those who are critical of the court's increasingly accommodationist stance on church and state argue wall of separation. Let's just keep church and state completely separate. Let's make it a black or white issue. Make it clean, no connection between church and state at all. I would say the court, when they kind of got started with this jurisprudence back in the 1960s, they were probably a little more leaning towards wall of separation. But over time, as we evolved culturally and politically, the court began to be increasingly accommodationist. Although, again, what troubles me a little bit there is typically accommodationist towards dominant religious groups, arguably perhaps not as protective of minority religious groups. So I see a certain amount of inconsistency there myself, as do other critics. Now, that being said, right, these things are always tricky. It's a continuum. The court did recently hear that church and state case involving public monies. Should they be allowed to go towards a religious school in Oklahoma as a charter school, public dollars? Ultimately, the court, spoiler alert, the court deadlocked on that case 4-4 because Justice Amy Coney Barrett recused herself in that case. I think she had connections with the law firm representing one of the sides in that case. So she recused herself and ended up breaking out 4-4. Which meant that the lower court's ruling stood, which I think was the Oklahoma Supreme Court, which said, no, you cannot use public money for a religious charter school. That's too close to a law regarding an establishment of religion. But it was 4-4. Right? I would expect, but hardly know, of course, right, that if Annie Coney Barrett had participated in that decision, she might have sided with allowing public money to go to a religious charter school. But we don't know that yet. But I'm assuming entities in Oklahoma will try to present to the court in the future another case raising the same issue, but without a conflict of interest for any of the justices. You do see, and these are some of the legacy cases more, you see a little bit more of the wall. Actually, no, you don't see the wall here. Sorry, you see accommodation, a lot of accommodation in the Supreme Court's jurisprudence, just in general. Although they used to be less accommodationist, now they're more accommodationist. But even old school, right? The court said, "In God we trust" on our currency. That's fine. It's low key. It's vague, right? We're okay with that. The Pledge of Allegiance, in God, one nation under God, often recited in public schools. The court said, "Nah, that's okay, as long as you're not forcing these kids to do the pledge," and it's pretty vague. One nation under God. Now, the president, all presidents, although they don't have to, have all used the Bible at their inauguration. It's just a tradition, and the court has said that's fine. How does the Supreme Court begin each new session itself? With a prayerful invocation by a religious figure. How does Congress begin each new session? With a prayerful invocation by a religious figure. Nevada's legislature used to do that, but some years ago they got rid of that as too much accommodationism. All right. All right, so two categories of free exercise of religion to talk about here. One is going to be, and it's going to be the primary discussion item here, general laws passed by the government that apply to everybody, including religious minorities who may claim that as a result their free exercise is being infringed, and then targeted laws targeted at religious minorities. Okay, so number one, right, recognize, look, free exercise, like any other right, is limited, right? There are boundaries as part of the social contract. No rights are absolute. Free exercise of religion, no different. Okay, so recognize that. Now, in terms of general laws, how the court deals with that is captured in a case from 1990 called Smith. So somewhat, the facts get a little convoluted. It's two Native Americans. They ingest peyote from time to time as part of their tribe's religious practices. As a result, they both test positive for the metabolites of peyote at work. They're fired for that reason. They then apply for unemployment from, I think it's the state of Oregon. And the state of Oregon denies it and says, no, you were fired for cause, for testing positive. And they go, yeah, but we're effectively being punished, right, for our religious beliefs translated into practices. Free exercise claim, right, against a general law that applies to everybody. Just say no to drugs kind of a thing, right? So the court looks at that and says, look, in cases like this, general laws that apply to everybody, but do incidentally burden a religious minority, the burden of proof is going to be massively on the shoulders of the religious minorities claiming an exemption from a general law. We're almost always going to side with the government. All right? That's the essence of Smith. And in this case, they side with the government. They said, the state has a compelling interest in making it a crime to ingest peyote or whatever, hallucinogenic you might wish to choose, and that overrides a religious minority's right to free exercise. All right? That's not a popular decision by the court. Both Democrats and Republicans don't like it. They think it's a little bit tyrannical, too much intention with legitimate free exercise claims. So they passed something called the Religious Freedom Restoration Act, or RFRA, bipartisan. And the court looks at it, right? And it may uphold most of it, but they do separate out one part of it that says, oh, hey, Congress says in this law, oh, hey, when there's a general law and a religious claim of exemption by a religious minority, the burden of proof is on the government to make out an extraordinary case, that generally the court should favor the religious minority and really hold the government's feet to the fire by demanding that if they're going to override free exercise claims with general laws, they've got to have a really compelling reason to do so. Right? Now the court rejects that. They say, no, look, we already said it's the opposite, right? We already said that in cases of general laws, the burden's on the minority to make out an extraordinary case. So you can't change that, because that's our interpretation of the First Amendment. Who has the final say on the meaning of the Constitution? The Supreme Court, not Congress, unless they're going to amend the Constitution, which is not what they did with RFRA, right? All right. So that part of RFRA is struck down. All right. So that's where we're at now, right? It's kind of status quo. Now, two cases that make it kind of interesting, Hobby Lobby from 2014, and then Masterpiece Cake Shop from 2018. So Hobby Lobby, right? That was a private corporation that was bound by the terms of the Affordable Care Act to provide contraception coverage for their employees. And they said, no, we don't provide contraception because we're pro-life and contraception goes against our deeply held religious beliefs. What the court says, and it's a little tricky, they said, okay, we're going to allow Hobby Lobby to get an exemption from the ACA on this issue because it does contravene their free exercise beliefs, practices, and but we're going to invoke the Religious Freedom Restoration Act, which we just got done talking about, right? Again, most of that was upheld, right, in Bourne v. Flores. So the court says, in this case, well, RFRA, right, which comes down on the side of religious minorities generally, it does permit closely held corporations where you've got just like a family corporation, and that family has strong religious beliefs. In those narrow sort of set of cases, RFRA does allow them to get an exemption from contraception coverage under the Affordable Care Act, right? So it's a pretty narrowly decided case. Incidentally, the Trump administration issued a rule late in his term in office to expand that exemption to all corporations, whether they're closely held by a family or not. I don't know that it ever went into effect. It was pretty late in the game, and I don't think the Biden administration takes quite the same view on that issue. So the Hobby Lobby does allow for a free exercise exemption of sorts here, but under RFRA, right? Not under the First Amendment per se, under RFRA, without getting into the thorny details of that interpretation of that law passed by Congress. And so the court is indicating, right, a real willingness to accommodate free exercise whenever they can. Very controversial case, as you would imagine. Because if you're a woman working for Hobby Lobby, you're denied, right, coverage for contraception. But court upheld that denial. And then another narrowly decided case, Masterpiece Cake Shop 2018. The court was looking at a decision by the Colorado Civil Rights Commission that a baker that bakes cake for the public, right? If they're asked to bake a wedding cake by a same-sex couple, they have to do exactly that. Otherwise, they violate Colorado civil rights law that says no discrimination on the basis of sexual orientation. So again, it gets a little weedy here. Sorry about that. And what the court rules is that there was evidence that the commission, the ones that gave that interpretation to Colorado law, that the Civil Rights Commission had demonstrated a general hostility to religion in their deliberations on this issue. And because they had demonstrated that hostility, that made them a biased decision maker. And in cases, in other words, where when you've got a civil rights commission at the state level interpreting state law, and in doing so, they evince hostility towards religion. In those cases, but those cases only, the free exercise of religion claim here is going to be upheld, right? That the owner of the bake shop does not have to bake cakes for same-sex couples, but only under those very factually specific circumstances, right? So again, that's an even narrower holding, right, than the Hobby Lobby case. That might really just be a one-off, right, sort of a situation. All right, but again, very controversial. The court was split like they were in Hobby Lobby. Right, these are hot button issues. But again, I think the court is trying to show, because they're more conservative these days, right? Trying to show that they are super sensitive to free exercise claims within the boundaries of the Smith decision from 1990, which is still the guiding case here. But it is undermined a little bit, right, maybe by both of these cases in a way. That's worth noting. Right? The court's always changing, always shifting. They're still, they haven't overturned Smith, but they've undermined it in some relatively small ways recently. And then finally, right, I said two categories of law here, free exercise. General laws, we just talked about that, right? Applicable cases, Smith, Bourne v. Flores, Hobby Lobby, Masterpiece Cake Shop. And then finally, targeted laws that are targeted at religious groups. That's Church of the Lukumi Babalu A from 1993. That was a situation down in a parish in Louisiana, which has parishes and not counties because they were originally colonized by the French. Kind of a unique system of governance down there. But it was a case where a local government passed a law banning the ritual sacrifice of goats. And you're like, well, that's weird. That's an oddly specific sort of a law. It is generally applicable to everybody, right? But it was very clear in that case. This was bullshit. They were targeting a Santorian church, a religious minority that had a tradition of ritually sacrificing goats. All right. So basically, I think it was the city council down there said, well, that's gross. That freaks us out. That's weird. We're going to ban ritual sacrifice of goats. Right? Clearly targeting a religious minority. Clearly targeting it. And that's what the court said. Oh, come on, man. Who are you kidding? This is not really a general law. I mean, technically it is, but it's not, right? It's targeted at one religious minority that's not popular, that violates their free exercise claims. Can't do it. And so targeted laws are basically never going to be upheld, absent some insanely extraordinary burden of proof satisfied by the government. So, all right, I know that's a lot, but that's what we need to talk about in order to talk coherently about how the Supreme Court has interpreted the free exercise clause of the First Amendment. Next up, still the First Amendment. That's a very busy amendment. That First Amendment also protects free speech. The court has defined that as a preferred freedom. We'll talk about that in just a moment. And essentially, if you're thinking about what is the meaning of that First Amendment, a good place to go on that would be John Stuart Mill's On Liberty, a brilliant book from back in the day, 19th century, a brilliant defense of a very wide, free, open marketplace of ideas as the best way to do things in a democracy. Has the court always been there on the First Amendment and free speech? Hell no. Hell no. Think about it, right? We begin this country with the Federalists in control. After Washington, Adams was president. They were worried about this rising young party called the Jeffersonian Democratic Republicans. And so what did they do? In 1798, they passed the Sedition Act, designed to make it a crime to criticize the government. Bad, bad news, right? Was that seen as a violation of the First Amendment? I don't think that it was, because we did not have a strong culture of free speech back then. Fortunately, although the court never did anything about it, Jefferson was against it, and once he was elected president, he got rid of that poisonous legislation. So we start out in a pretty shaky way, right, where we don't have any strong sense of free speech necessarily, certainly not coming from the Supreme Court. That doesn't really come until the early to mid-20th century. We get it in two famous cases, Schenck, which went against free speech, although the court did say, hey, look, free speech can only be punished if it poses a clear and present danger to the nation. This was a guy arguing against participation in World War I, against U.S. participation. He was distributing pamphlets in Yiddish on the waterfront in New York City, trying to encourage resistance to the draft. That was considered by the court to be a clear and present danger to the nation, and he was therefore allowed to be prosecuted and convicted of violating, I think it was the Espionage Act, and put in prison. Bad news, right? Bad news. Over the summer, Justice Oliver Wendell Holmes, maybe our greatest Supreme Court justice, certainly in the top 3 or 4, along with his colleague Brandeis, they changed their minds and they realized, you know what, we screwed up in Schenck. It should be clear and present danger, but we need to use it more aggressively to protect free speech. So in Abrams, a very similar situation in the fall of 1919, after that summer break that they had, Holmes and Brandeis write a dissenting opinion, but still an opinion that argues for a stronger vision of free speech, one that looks more like John Stuart Mill's On Liberty. So there we see the beginnings of change, the beginnings of a commitment to genuinely free speech, even if it irritates us, even if it's not popular, especially if it's not popular. The court has a responsibility to do exactly that, right? To be, in some cases, counter-majoritarian, to fight against majority tyranny. And there are there's some forward progress and then some backsliding during World War II because of national security issues, the Red Scare after World War II, McCarthyism, again, bad news. The court endorses that bullshit. We lose a lot of free speech ground. But then I would say after the mid to late 1950s, the court and the American people finally get serious about free speech, finally, in a serious and consistent way. So I would say since then, the court and we the people have been pretty good on free speech, pretty good. Not always, but pretty good. And something today that we take for granted. The standard these days is clear and imminent danger. So you can talk about, in a very general way, using violence to overthrow the U.S. government. You can definitely do that, highly protected. But if you say, hey, I want violence against the U.S. government, let's gather here, let's talk about a plan for blowing up this building, and then let's kill these people, right? You do that, whoa, you've crossed the line. You are now posing a clear and imminent danger. The danger is clear, it's imminent, it's about to happen. You've made very specific plans. That is not protected, not protected. But just about everything else is, right? Just about everything else is. Westboro Baptist Church, see that video again on Constitution USA. Super unpopular, super inappropriate, deeply disrespectful to members of our military and the nation, and yet protected, right? Protected, the court said, protected. The government can regulate it a little bit. They can say, stay 50 yards away from the funeral, don't use megaphones, that sort of thing, but mostly pretty much protected. Flag burning, protected. Is that popular speech? Heck no. Would most people vote against that as protected speech? They would. But the court has said, hey, look, you got to keep that marketplace open. The best remedy to bad speech is good speech, not censorship. That's where the court's at these days, by and large. Some think they've gone too far. Some think they've gone too far. That's an ongoing debate, of course. But right now, at least, the court has been very strong on free speech in recent years. And again, something maybe too strong. Okay, so the right to keep and bear arms. For most of our history, the Supreme Court gave kind of a minimalist read to that amendment. Remember, it starts out with a well-regulated militia being necessary to the security of a free state. The right of the people to keep and bear arms shall not be infringed. They gave a lot of emphasis to the first part of that language. You got to be a part of a well-regulated militia that's protecting the security of a state like Nevada or Wisconsin. So who fits that definition? People who belong to the Nevada National Guard, people who belong to the Wisconsin National Guard, right? So, in short, right, for most of our history, the court gave the Second Amendment a very minimalist reading. Now remember, states can go beyond what the Bill of Rights protects. They do it all the time. So, did we have no protections for gun rights for most of our history because of the court's approach? No, we have plenty of protections at the state level, like in Nevada, built into our Constitution. So the Bill of Rights, right, sets a floor, not a ceiling. States can go above the floor, and they often do. Nevertheless, there's been an argument for a long time that the court had been getting it wrong. And in 2008, the court goes a different direction entirely, and they say, yeah, the Second Amendment does start out talking about a well-regulated militia, but the core of that is that last part of that opening where it says the right of the people to keep and bear arms shall not be infringed. So they said that's universal. That applies to every adult American citizen. That was D.C. v. Heller. Very kind of a revolution in the Second Amendment. Pretty recent. And in 2010, they applied that understanding to the states as part of that ongoing process of selective incorporation that we've already talked about. Okay. Now, for some while after that, lower courts were sort of set adrift as to what standard they should use now to evaluate gun control laws. Sure, it's a universal right, but how do you evaluate that versus gun control laws? When do gun control laws violate the Second Amendment? When do they not? And they adopted sort of on the fly kind of a reasonable regulation standard, right? We're going to uphold gun regulations that we deem to be reasonable. We're going to strike down ones that we deem to be unreasonable. Pretty loosey-goosey as a standard, right? And under that standard, they were generally, actually quite strongly upholding the vast majority of gun control laws. Things like background checks, universal, like here in Nevada. Things like red flag laws, right? Deny or maybe even take guns away from people who've shown red flags like criminal record, that sort of thing. So the court, however, more recently, and I think I have a separate video in this module, check it out. I go into this in great depth, but the court said, well, okay, we're going to set a standard here for how to evaluate gun control laws, and it's going to be original intent, sort of the holy grail for judicial conservatives now for many decades. All right, let's go back to what the Second Amendment meant when it was passed in 1791, and that's what it'll mean for all eternity unless we the people amend the Constitution. Original intent. And they said that's the deal with gun control laws. And so they said, more specifically, look, if there's a gun control law in place today, you have to find a similar gun control law from 1791 in one of the 13 states in order to uphold it. Which is a pretty tough standard to meet, depending on how closely these two things need to match. Again, check out that separate video in the module. And under this standard, the courts have been striking down a lot of gun control laws because it can be hard to find similar ones from 1791. Don't get me started. So that's kind of where we're at today. And again, indeed, regardless of how the federal courts read the Second Amendment, right, which I know is an important issue, of course it is, because it sets a national standard. States are able in many cases to go beyond that in protecting gun rights, and they often do, and they have right from the beginning of the American Republic.